We're coming to you again from the annual spring meeting of the American Bankruptcy Institute. I am ABI's editor-at-large, Bill Rochelle, and sitting with me is my longtime friend and former colleague, Rob Feinstein, who is the anchor of the New York office of Pachulski, Stang. You know, Rob, you are involved in what I think is going to be the blockbuster Chapter 11 case before the U.S. Supreme Court in the next term to begin in October. As a little background for those of you who are not following everything filed in the Supreme Court, there was a case decided a few months ago in the Third Circuit called Jevick. Raises the question of whether or not gifting, as it's called, is in violation of the bankruptcy code, and the Third Circuit says it's perfectly okay to make gifts, which is to say, give money to an unsecured class of creditors that bypasses others in the order of priority. And you, Rob, have been involved in that case from the outset.
Yes.
Where we sit right now is with a petition for certiorari filed in the Supreme Court. What the court did about a month ago was to request that the U.S. Solicitor General give his opinion on whether or not the court should grant the cert petition. I understand that there's a possibility that the Solicitor General could put in his response before the end of the term, in which event, my guess is, I don't know how you feel about it, but I'm guessing the Supreme Court will grant cert, and that means the case would be heard probably October, November, thereabouts, maybe
right.
December. If they don't consider the cert petition until the first conference in the end of September, then this case, if it is granted cert, will come up sometime January, February, thereabouts. In any event, Rob, I hear tell that you were involved to some degree with the cogitation by the Solicitor General and the Justice Department on whether they should recommend this case to be heard by the Supreme Court. So tell us a little bit about that process.
Well, I want to be careful about commenting on the merits of a pending case, but from a process standpoint, this has been a fascinating ride in that this case started in, I believe, 2009. We represented the Official Committee of Unsecured Creditors. We had standing to bring an LBO cause of action against the bank under the DIP order, and then we got standing to extend that to Sun Capital. We were hit with a motion to dismiss, and the judge denied it, so we had a viable LBO cause of action. And then we went about settling it under a global settlement that we attempted with all the constituents, including priority claimants who held warrant claims. We couldn't settle with them, and ultimately ended up with a structured dismissal and a gifting settlement whereby money was given to the general unsecured creditors and to administrative claimants, but it went around the Warrant Act claimants. Judge Shannon approved that, and then it was appealed to the district court. The district court affirmed. It also said that the case should be dismissed for equitable mootness, which is now pretty much a disfavored doctrine in the Third Circuit. But that decision was then appealed to the Third Circuit. As you noted, the Third Circuit affirmed, and then the appellants, the Warrant Act claimants, filed a cert petition. The appellees, who were the creditors committee and the defendants in that litigation, Sun Capital and CIT, as well as the debtor, all joined in opposing the cert petition. It was fully briefed, and I'm learning all about Supreme Court practice now. It's fascinating. There are three options when the court is presented with a cert petition: cert granted, cert denied, or inviting the Solicitor General to submit a brief, which is what the court decided to do. And this conference of the court happened just after Justice Scalia's death. In fact, it was put off a week because of his funeral, but we were told that in late February that the decision had been made to seek briefing from the Solicitor General. So our understanding is that that brief should go in by the end of May. And in advance of that, the Solicitor General invited all the parties' counsel to meet with him and his colleagues. And that meeting occurred last week in the Justice Department.
Now let me ask you this before we talk about that meeting. Does the government have a dog in this fight, or perhaps in some similar cases?
Well, look, the part of the government is the U.S. Trustee's office, and the U.S. Trustee has been consistent in cases throughout the country, opposing gifting and opposing structured dismissals.
Now, what about in the LCI case, where the government had a priority tax claim that got nothing because of a structured dismissal?
Well, it was a slightly different set of facts, but ironically, you may not know this, is that the life care case was argued on the same day as Jevic down the hallway. My partner, Brad Sandler, represents the committee in that case, and I represent the committee in Jevic. So the IRS was the agreed party in that case. They lost in the Third Circuit. Different kind of a structure to it, but they lost and decided not to appeal. So that decision has become final. But the Warnock claimants in Jevic appealed. The U.S. trustee, who had been an objector in the bankruptcy court, didn't pursue the appeal, but when the case went to the Third Circuit, they took advantage of the ability of any government agency to file an amicus brief. So they filed an amicus in the Third Circuit. Again, the Third Circuit affirmed the ruling. But now, as it's being considered for certiorari, the U.S. trustee is a very active participant in the discussion, and they continue to steadfastly oppose structured dismissals around the country, as well as gifting in 1919 settlements.
Well, Rob, let me ask you this. Gifting is a situation in which somebody gives money that does not follow strictly the rules of priority.
Yes.
First, give us the arguments why it is permissible, and then I'll ask you why it might not be permissible under the bankruptcy code.
Sure. Well, look, it's permissible because courts said it's permissible. I'm an advocate, and I read the circuit cases carefully. And what you had in the context of plans of reorganization is the Armstrong World case in the Third Circuit that said you can't make a distribution out of priority under a plan. You have to follow the absolute priority rule, following the fair and equitable standard in 1129, where the concept is embedded in the statute. And in the Second Circuit, you have the DBSD case, which held the same way. You also had the Iridium case in the Second Circuit, which was a 1919 motion, not a plan, and the court allowed a little window to stay open for out-of-priority transfers in exceptional circumstances. The court said nonetheless that adherence to the absolute priority rule will nonetheless be the most important factor in a court considering the approval of a 1919 settlement. But it was the most important factor, but it was not a bright line litmus test.
Now, do you think...
And of course the Third Circuit was silent on this until the Jevic case. There had been a case that made it to the district court called Kanos Partners, which approved gifting and a structured dismissal. So as an advocate, we had the Iridium case and we had the Kanos case and an open playing field in the Third Circuit.
But do you have a split of circuits?
Yes, there's an older case called Awico from the Fifth Circuit from the mid-1980s. And didn't get much notice, but that case held a long time ago that you can never deviate from the absolute priority rule in a 1919 settlement. And then when Iridium came along, Iridium discusses Awico briefly, reached an opposite conclusion. So you already had a circuit split as of the time that Iridium was decided, but Iridium wasn't appealed. But then when it came to Jevic, now you can see that there is a circuit split with Jevic and Iridium on one side and Awico on the other. And of course that's a classic marker for a certifiable case.
Now I know you're on the other side of the issue, but what is the argument that you shouldn't be able to have these gift plans?
Well, I hope that this private conversation won't be quoted, Bill, but if you're a purist, you believe that the absolute priority rule is a fixture of the statute. And there are some cornerstone principles underlying the bankruptcy code. One of them is equality of distribution, and another is fair and equitable, that you follow the absolute priority rule in order of distribution. So by deviating from that, we have committed blasphemy in some eyes, but I also think we've created some rough justice in very difficult times where you want to get distributions to people. It could not have been done in Jevic absent the gifting structure dismissal. So, it was either that or let the secured creditors take all the money and go home.
Well, the last point you make is really the pregnant point, which is to say that were there not this settlement, there would have been no recovery ever, anytime, by unsecured creditors.
A finding by the bankruptcy court that was the case.
Pretty powerful, equitable argument. Over the last several years, the powers of bankruptcy courts as courts of equity have gone up and down. Maybe this will give next year the Supreme Court an opportunity to decide which way they're going to go on the equity powers of the courts. Mm-hmm. Well, there you have it from the horse's mouth from Rob. It does sound like the Solicitor General will have a brief on file with the court, as he said, by May. That means that by all rights, likely as not, the Supreme Court will hold a conference by the time they have their breakaway at the end of June, which means, Rob, maybe we'll find out before it becomes July that I'm going to see you in the well of the Supreme Court next fall.
Well, I've gone ahead and gotten myself admitted thanks to our former colleague Dick Leave and another sponsor. I'm now a full-fledged member of the United States Supreme Court Bar.
Well, good luck and thank you.
Thanks very much.